Hello people, in this video we are going to discuss about the constitution of a country. Now let's see the definition of it first. It is a set of rules and principles that defines the nature and extent of the government. That is how a government should be and how it should behave. It's the rules and the principles which are mentioned in the constitution. Let's see it further a little. It is usually in a form of a document or a book. So when we say a constitution of a country, we are talking about a kind of a book or a kind of a paper or a document where something is written that how a government should be. So it is a kind of a book first. Another thing is most constitution seeks to regulate the relationship between institutions of the state. That is the relation between the legislature, the executive and the judiciary. As we all know that government has three pillars, that is the legislature, the executive and the judiciary. So government defines that how these three bodies should work and what should be the relation in between them, and also the various other government departments. The constitution in some cases, especially the codified constitution, we will talk about the codified in the later part of this video. So in certain constitution it also acts as a limiter to the state power. What does it mean? That is the limiter to the state power. That is that it says that you cannot do something. It limits on the powers of the state. State means the government. So it limits the power of the government. That is by establishing lines which a state's rulers, that is the government itself, cannot cross. That you cannot do something or you should not do something. For example, you cannot change the fundamental rights. So these kind of things are usually mentioned in a constitution, and whatever is written or suggested in the constitution becomes the law of the land. This is something to be pondered over. That becomes a law of the land, and every person in the country has to abide by that law, abide by such law. So whatever is written in the constitution in that particular book, everyone on the land, all the citizens and all the people in the country have to follow that. So this is something kind of a book that we are talking about, that the government has to work accordingly, and also the people. Now let's see the types of the constitution, and we are talking about the democratic constitution, that is which are as per the agreement between the citizens and the locals of the country. Now let's see the types of the constitution. We usually have two types of constitution. The first one is the codified one. This is a codified constitution, and the other part is the uncodified. That is something which has been coded or written and something which has not been written. The codified part are usually those kind of constitution which are written in the single act or a single book. So it's a single book in which it is written. Most of the countries of the world are having codified kind of a constitution. So if we talk about in general, we have codified, that is we have written constitution in a single book. In a single book, as we have mentioned earlier, that the constitution is usually a document or a book. Now let's see the uncodified part. That is those constitutions which are not written, or they themselves are of two types. The first one is the fully written one. Now this is something that we have to see in detail. That is uncodified kind of a constitution which is fully written, but it is usually in several books. As we already said that a codified constitution is written in one book, only one book. The uncodified but written constitution is usually found in several books, in several books. For example, at present in the world we have San Marino and Saudi Arabia having these kind of constitutions. San Marino gets governed by 6 books. That is, their constitution is bifurcated or written in 6 volumes of books. And Saudi Arabia has a document which has several articles in it and which refers to the Quran, the Holy Quran. That's the Islamic book, the Islamic holy book. It says that whatever we are getting governed are because of the Quran, whatever is written in the Quran. So these kind of constitution are made up of several books. And then there's other kind of a constitution which is the partially written constitution. Here the constitution is written in several documents. That is, whenever parliament passes a rule or an act, that becomes a part of the constitution. So that becomes an article of a constitution. That's one. And another thing is it's governed by the conventions and customs. It's governed by the conventions and the customs, that is something which is already prevalent, and the government or the parliament never want to change it. Even that becomes a part of this particular uncodified kind of constitution. For example, in United Kingdom, the election day is always considered on Thursday. So that's also a custom, but it has been followed, and Parliament never makes an article regarding that. So even that becomes a part of constitution. And yes, it evolves over the time, as we have said that whenever Parliament passes an act, it becomes a constitutional law, it becomes a constitutional rule. So as day passes, as the years passes, or as the generations passes, the size of the constitution usually increases. But in cases of single act, that is the codified constitution, and usually in the written type of constitution, they are limited in nature, they don't get changed easily. As we all know that the constitution, whatever it says, it becomes a law and everyone has to abide by it. Now let's think or imagine, what if something is written in the constitution but it becomes outdated, or it becomes something which is not required as of now? Then what should one do? Well, in such cases we have amendment to the constitution. That is, we can change the constitution, we can amend the constitution in parts. Whatever law or rule that we don't find appropriate, we just go and amend the constitution. To amend the constitution, there is a level of difficulty. The first case is a simple amendment, a simple kind of an amendment, a simple amendment where for example, a 50% kind of majority of the legislature can change the constitution. Or let's say in a legislature there are 100 guys, 100 member of parliaments or 100 congress people. Then those 100, out of those 100, 51 people minimum are required to amend the constitution. Then that will be called as a simple amendment to the constitution. Other case is the complex one. The amendment is a complex kind of a case here. That is where 75% or plus kind of a majority of legislature is required. That is, out of 100, there are 75 people at least are required in the majority to change that kind of law or rule that they want to amend. Well, these numbers can differ significantly depending on the country about which we are talking about. Then there is a case of a very difficult kind of an amendment where it becomes imperative to the people of the Congress or the people of the Parliament to think about it, and for that matter they require a lot of people, a lot of majority to change those laws. For example, a 50% of central and 50% of majority of the state legislature in cases of federal countries, in federal government cases. Such kind of things may exist. That is, you have to change, you have to make these rules by passing the amendment bill in several legislatures. That is, the central legislature and the state legislature. Or there also could be a case where the legislature and the referendum both are required. That is, the majority of the legislature that they want to change a particular kind of a law, and also a majority by the public. That is, the approval by the general public is also required. Even that would be a case of a very difficult kind of amendment in the constitution, because you require a huge public to change this. Then there is another kind of amendment which is called as impossible kind of amendment. That is, no modification to the basic structure of the constitution. That is, you cannot change the constitution. Such kind of thing is called as, or such kind of difficulty is called as impossible or no modification to the constitution. In constitution, for example, the case of fundamental rights, you cannot change them. There are certain constitution which declares that you cannot, the members of parliament or the government cannot change the fundamental rights given to the general public. They cannot change it. It is impossible. And then there is a case of revolution, that is to throw the government out and the constitution. Well, this is the extreme case when the people in general do not want or do not like their constitution. That is the behavior of the government or behavior of the behavior of the government machinery. In that case, they can simply come out in large quantities. That is, the majority of the people, majority of the country's people come on the street. They just throw out the government and throw out the constitution, and they start making a new constitution. Well, that's a case of revolution and an extreme case. In this case also, we can say there's an amendment to the constitution, or rather the whole constitution gets amended. At the end of the video, let's see the good to know facts here. The Constitution of India is the longest written constitution of any sovereign country in the world. That is, it's the biggest constitution, it's the largest constitution. It's a big book. It's a big book with lots of chapters and lots of schedules and lots of articles. And at the same time, the Constitution of United States of America is the shortest written constitution in the world. I hope I was able to make this chapter clear. Thank you.